Welcome back to Real Estate School. Today we'll be discussing the legal status of a purchase agreement. This will be helpful for your licensing exam. Also, stay tuned to the end. We're going to give you a little quiz to see how you do, some questions that you could see on your state's licensing exam. Also, wanted to remind you to join me 2 Saturdays a month live in the classroom over Zoom video. We're going to discuss all these terms and concepts and make sense out of the things that you've been studying, including, yes, helping you through real estate math. Go to realestatetutorbob.com to learn more. Enjoy the video. The legal status of a real estate purchase agreement can be described in one of 4 different ways: valid, void, voidable, or unenforceable. A valid real estate purchase agreement meets all the essential elements that make it legally sufficient or enforceable and is binding in a court of law. A valid contract is one which meets the legal requirements for validity. These requirements are offer and acceptance, consideration, legal purpose, free and voluntary consent, and legally competent parties. Offer and acceptance, or a meeting of the minds, requires that a contract involve a clear and definite offer and an intentional, unqualified acceptance of the offer. In effect, the parties must agree to the terms without equivocation. An offer is a promise made by one party, requesting something in exchange for that promise. The offer is made with the intention that the offeror will be bound to the terms if the offer is accepted. An acceptance is a promise by the offeree to be bound by the exact terms proposed by the offeror. Proposing any deviation from the terms of the offer is considered a rejection of the original offer. The changed offer is known as a counteroffer. The counteroffer must be accepted for a contract to exist. The next essential element, consideration. A purchase agreement must contain a two-way exchange of valuable consideration as compensation for performance by the other party. The exchange of consideration must be two-way. The contract is not valid or enforceable if just one party provides consideration. Consideration must be good and valuable between the parties. The courts usually do not inquire into the adequacy of consideration. Adequate consideration could be a promise of love and affection between relatives, or it could be a substantial sum of money. Our next essential element, legal purpose. The content, promise, or intent of a contract must be lawful. A contract that proposes an illegal act is void. That is, even with all the other elements, offer and acceptance, consent, consideration, and competent parties, the contract must have a legal reason for existence. A contract for a legal purpose or for performance of an act against public policy is not a valid contract. Consent. The parties must create the purchase agreement in good faith as a free and voluntary act. A mistake, misrepresentation, fraud, undue influence, or duress would deprive a party of that ability. If any of these circumstances is present, there is no valid offer and acceptance, and the contract is voidable by the injured party. And our last essential element is competent parties. The parties to a contract must have the capacity to contract, and there must be at least 2 such parties. All the parties to the purchase agreement must have legal capacity, meaning they must be of legal age and have enough mental capacity to understand the nature or consequences of their action in the contract. In most states, 18 is the age of contractual capacity. If it is discovered that a party is not legally competent, the contract is voidable at the option of the person who lacks competency. A purchase agreement must contain all these essential elements for it to be valid and enforceable in court. Without one of these elements, the contract could be described as either void or voidable. A contract that is missing consideration, for example, would be void. A void contract is an agreement that does not meet the test for validity and therefore is no contract at all. If a contract is void, neither party can enforce it. The use of a forged name in a purchase agreement would make that purchase agreement void. A voidable contract is one which initially appears on the surface to be valid, but is subject to rescission by a party to the contract who is deemed to have acted under some kind of disability. Only the party who claims the disability may rescind the legal effect of the purchase agreement. For example, a party was a victim of duress, coercion, or fraud in the creation of a contract and can prove it, may disaffirm the contract. An unenforceable contract may also appear on the surface to be valid. However, neither party can sue the other to force performance. For example, an oral purchase agreement for the sale of a parcel of real estate would be unenforceable. The defaulting party could not be taken to court and forced to perform. However, if both parties comply with the terms of the agreement, go to close, and exchange the ownership for consideration, we have a transfer of ownership, and now the contract is completed. Our first question. A person approaches an owner and says, "I'd like to buy your home." The owner says, "Sure," and they agree on a price. What kind of contract is this? A. Implied. B. Unenforceable. C. Void. D. No contract. Some might say implied, but it is not implied. It is express. They discussed it and agreed on terms. They've just done this verbally. And what do we have if we have a verbal contract? It's unenforceable. B. Question number 2. A contract for the sale of real estate that does not state the consideration and provides no basis on which the consideration could be determined is considered A. Voidable, B. Executory, C. Void, D. Enforceable. In this case, without including consideration an essential element, the contract would be void. Question number 3. If upon the receipt of an offer to purchase a property, the seller makes a counteroffer, the prospective buyer is A. Bound to the original offer, B. Not able to counter the counteroffer, C. Bound to whichever offer is lower, or D. Relieved of the original offer. When the seller made a counteroffer from the buyer's original offer, this terminated the buyer's original offer. The answer would be relieved of the original offer, D. Question number 4. When suffering from mental illness that caused delusions, hallucinations, and loss of memory, a person signed a contract to purchase real estate. Which statement regarding the contract to purchase is true? A. The contract is voidable. B. The contract is void. C. The contract lacks consent. D. The contract is fully valid and enforceable. In this case, the answer is A. The contract is voidable. Question number 5. An important legal feature of a contract is A. It represents a meeting of the minds. B. It must use precise wording in a document. C. It is not voidable. D. It can be created only by an attorney. Well, the best answer here would be A. A legal feature of a contract is that it represents a meeting of the minds, a complete agreement between the parties. A. Next question. According to contract law, every valid contract is also A. Void, B. Enforceable, C. Enforceable or unenforceable, D. Voidable. Every valid contract is also C. Enforceable or unenforceable, such as a verbal agreement is a valid agreement. It's unenforceable, but it's valid. Our last question. An unscrupulous investor completes a contract with a buyer to sell a property the investor does not own. The sales contract for this transaction is A. is voidable, B. must be in writing, C. is void, D. is illegal yet potentially enforceable. Well, selling a property you don't own, this contract is void. Well, I hope you did well on your quiz. As usual, please subscribe below and ring that bell, and we'll let you know about our next video as it comes out. Thank you for watching.